Good morning.
Oh, okay. So, fire away. That's good.
Good morning. The hearing will come to order this morning. The Oversight and Reform Committee is holding its first member day hearing. This is an opportunity for members to discuss their legislative priorities that are within the jurisdiction of the committee. We're meeting to hear from members, so I'm going to be extremely brief. I look forward to hearing about the important bills that members want to discuss. Many of the legislative issues that come before this committee are not partisan. Most members want to improve the nuts and bolts operations of the federal government, which much of the committee's legislative jurisdiction is focused upon. So I would encourage members to work with us and across the aisle to develop bipartisan legislation that may actually have a chance to be enacted. I thank everyone who is here today for their interest in this hearing, and now I yield to the distinguished ranking member, Mr. Jordan.
Thank you, Mr. Chairman. I'll be brief as well. I look forward to hearing from these two fine Republican members, and I'm sure some Democrat members as well, the gentleman from Alabama and New Jersey, next to Ohio, two of my favorite states. So we look forward to hearing, and Mr. Kilmer as well. We look forward to hearing everyone's testimony. And with that, I yield back, Mr. Chairman.
Thank you very much. I want to thank the ranking member for your statement, and now I welcome the first panel of member witnesses who will describe their legislative proposals that they would like the committee to consider. We have circulated a list of members wishing to speak as well as the testimony received in advance. All testimony will be made a part of the hearing record. Each member will be allotted 5 minutes to describe their proposals and field questions if that is appropriate. So we'll start with Mr. Smith, then we'll go to Mr. Brooks, and then Mr. Kilmer.
Thank you so very much, Mr. Chairman and Ranking Member. Thank you for this privilege and opportunity to be here today and testify. Mr. Chairman, hotels have a unique connection to human trafficking, as they are often the sites that traffickers use for sexual exploitation of both children and adults. In addition, hotels sometimes contract, many of them unwittingly, with unscrupulous contractors who are involved in labor trafficking of household staff. However, when hotel workers at all levels are trained to properly recognize and report potential trafficking, hotels are transformed into a safer place for potential victims and a hostile place for the exploiters. H.R. 1427, which I introduced, joined by Carolyn Maloney from New York, ensures that hotels have an incentive to train their workers. That incentive is earning the business of the U.S. government travelers. Over the last 3 decades, we have seen tremendous improvement in hotels' awareness of trafficking on their premises. Through the educational work and expertise of ECPAC, for example, the Code Project, as well as hotels seeing the trafficking problem on their own and deciding to take comprehensive action, many of the largest hotel companies have already developed their own internal training. For example, Marriott, which has a force of 750,000 people, has already trained 500,000, and they're going to train them all, to recognize and to report trafficking. Hyatt and many others have done tremendous work on that as well. Many hotels partner with law enforcement and advocacy groups and have spent considerable resources to be effective in the fight against human trafficking. This bill, H.R. 1427, aims to reward these hotels by prioritizing them for government-sponsored travelers where practical. In addition, the bill seeks to inspire hotel chains and franchises that have not already implemented training to do so, if for no other reason to enhance their bottom line, but hopefully because they want to end this terrible cruelty of human trafficking. U.S. taxpayer dollars should not be going to hotels that turn a blind eye to human trafficking when there are other responsible hotel options available. H.R. 1427 will ensure that that happens. It will require that each hotel has a zero-tolerance policy regarding human trafficking as defined by federal law, ensure that their employees have been trained on recognition and reporting of human trafficking, and there are telltale signs that can easily be conveyed to individual workers, post a place accessible to employees or employee handbook or in the handbook on the signs of human trafficking, and keep track when something occurs, doesn't look right. Don't be vigilantes. Tell law enforcement, and they will get involved and hopefully take the appropriate action. GSA will keep a list of hotels that meet these criteria for use by government travelers, have available sample training, and work with Department of Homeland Security, the Blue Campaign, on this as well. You know, we have, as you know, FedRooms, which is the official government list. It helps people to book a room. That would also be included on their website as well. So I would just finally say that I began working on human trafficking, Mr. Chairman, in 1995. I've authored 5 major laws, including our landmark Trafficking Victims Protection Act of 2000. It took 3 years to get that enacted. It was signed into law. It's having a major difference, or impact, I should say. This, I think, will make a major impact on getting the private sector, which is already doing some very, very good things, to do even more. And we can use our dollars to ensure that when our people travel in the federal employment sector, they are using or at least utilizing hotels that are more likely to be on the side of protection. I would also say that the Frederick Douglass Trafficking Victims Protection Act that I authored last year was signed into law just a month and a half ago. We had a provision in there dealing with airlines to ensure that there is a preference given to airlines like Delta that has trained their flight attendants and employees to be situationally aware as well. We want to apply it to the hotels. Yield back.
We'll take questions of each individual. I don't have any questions, Mr. Jordan. Thank you very much, Mr. Smith.
I just wanted to say, I just wanted to thank Mr. Smith for his commitment to this issue and protecting the sanctity of life and so many other important issues for a number of years. You've led in that area, and we really appreciate it.
Thank you very much. Representative Brooks.
Chairman Cummings and Ranking Member Jordan, thank you for the opportunity to appear and share my insight. I submit the inclusion of the citizenship question on the next census is not only common sense, it is constitutionally required. Section 2 of the 14th Amendment states, quote, "Representatives shall be apportioned among the several states according to their respective numbers, counting the whole number of persons in each state, excluding Indians not taxed," end quote. Section 1 of the 14th Amendment states, quote, "No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws." This latter provision is the Equal Protection Clause. After the 2010 census, illegal aliens were counted for reapportioning congressional districts and electoral college votes. Hence, states that had fewer illegal aliens saw a shift of their political power to states that had more illegal aliens. Law-abiding states lost not only congressional representation in Congress, they also lost electoral college votes that elect the President of the United States. I submit the citizenship power of citizens in low illegal alien count states was diluted as their congressional seats and electoral college representation was disproportionately cut. Similarly, the counting of illegal aliens for reapportionment of political power purposes violates the 14th Amendment's Equal Protection Clause by unconstitutionally diluting the representative and political power of citizens who live in low illegal alien population states. In that vein, the United States Supreme Court has consistently upheld one man, one vote principles that prevent the dilution of a citizen's voting rights. For example, you have one man, one vote principles applied in our own congressional districts, wherein congressional district populations must be as equal as possible according to the, quote, "as nearly as is practicable," end quote, standard, subject to deviation caused by, quote, "legitimate state objectives," end quote. Although there is no bright-line test, congressional districts that have a 1% or more deviation usually do not withstand constitutional one-man, one-vote requirements, and constitutional districts with deviations of less than 1% usually withstand constitutional scrutiny. Similarly, I submit it is unconstitutional deprivation of 14th Amendment equal protection rights under one-man, one-vote principles to count illegal aliens for the purposes of reapportionment of congressional power and electoral college votes, because if illegal aliens are counted in the distribution of congressional representation and electoral college votes, then some citizens' votes are worth more or more powerful than votes of other citizens. That is wrong. Congressional districts with lower percentages of citizens because of higher illegal alien concentrations grant their citizens an unequal representative power when compared to citizens in districts with higher percentages of citizens and lower percentages of illegal aliens. Alabama's state motto is Audimus Jura Nostra Defender, which translates into, "We dare defend our rights." I am here today to defend the rights of Alabamians and all Americans whose voting rights are diluted. Alabama will likely lose a congressional seat and an electoral college vote if illegal aliens are included in the count for reapportionment of congressional seats and electoral college votes. As such, the voting rights of Alabama citizens will be illegally diluted, and the equal protection rights of Alabama citizens, the one-man, one-vote rights of Alabama citizens, will be unconstitutionally denied. In Alabama, we do dare to defend our rights. In that vein, the state of Alabama, represented by Attorney General Steve Marshall, and I, as an Alabama citizen and member of Congress, last year filed suit in the Northern District of Alabama to challenge the counting of illegal aliens for the purposes of political power distribution. Also, there are bills pending before this committee that relate to this issue. I urge this committee to appropriately address them by defending the Constitution's Equal Protection Clause and long-held one-man, one-vote principles. I appreciate the opportunity to appear before you today.
Thank you very much, Mr. Brooks. Any questions? Jordan.
I just want to, again, thank Mr. Brooks for raising this important issue, and I know his involvement with the legal action with his state. So thank you for taking the time to talk to the committee about something that I think is just fundamental. We appreciate it.
Thank you very much.
Mr. Jordan.
Let me say to all of our witnesses, feel free to leave, Mr. Smith and Mr. Brooks. I know your time is not, what's the matter? Oh, I'm sorry. Well, let me finish. I'm just out of respect for your time. When you finish, we will not be offended, okay? All right, now go ahead.
Yeah, I'd just like to thank you for doing this as well. I'm sure if the average American understood that there are people up here who actually are succeeding in counting people here illegally towards reapportionment, I think they would be stunned. I would bet very, very tiny number of Americans know that's the goofy way that we're operating here. So thank you for carrying the torch.
Thank you, Mr. Grothman.
Thank you very much. Mr. Kilmer.
Thank you, Mr. Chair. I want to thank you and the ranking member for holding this member day. And when I was first elected to the House, I joked with folks back home that it was going to be a fixer-upper. When renovating a house, though, you don't just diagnose problems like water in the basement or an outlet that doesn't work. You have to fix the structural flaws that that are causing those problems, like plumbing and electrical systems. As the chair of the new Select Committee on the Modernization of Congress, I'm excited to work with you with this committee to identify some of those structural flaws and to begin to develop some common sense bipartisan solutions that will hopefully get Congress back to work. As folks in this room know, some of our biggest challenges relate to the budget and appropriations process in the wake of the recent 35-day government shutdown, the longest in our government's history. It's clear that we need to do better. And while I'm eager for the Select Committee to get to work on developing recommendations for bipartisan solutions to address that problem, having served this past year on the Joint Select Committee on Budget and Appropriations Process Reform, I recognize that that job may be easier said than done. Knowing that, I believe it's important that our hardworking federal employees not be held hostage in the event of future government shutdowns. If partisan posturing leads to a government shutdown, I want to make sure civil servants are not left holding the bag. And that's why I introduced H.R. 588, the Federal Employee Civil Relief Act. The bill addresses the real threats that federal workers face when they miss a paycheck because Congress has failed to pass its spending bills on time. Consequences like losing their homes, falling behind on student loans and other bills, having their car repossessed, or losing their health insurance because they've been furloughed during a shutdown or required to work without pay. Modeled after the Service Members Relief Act, which has been the law of the land since the 1940s, this legislation would safeguard workers impacted by a shutdown from the following: being evicted or foreclosed, having their car or other property repossessed, falling behind in student loan payments, falling behind in paying bills, or losing their insurance because of missed premium payments. The protection would last during and 30 days following a shutdown to give workers a chance to catch up on their bills once their paychecks are restored. The last partial government shutdown hurt more than 800,000 federal workers in all 50 states. Across 800,000 kitchen tables, hardworking people were forced to figure out how to pay bills and provide for their families without an income. And this partial shutdown only impacted about a quarter of the federal government, so we know the consequences could have been much worse. Federal workers are public servants. They shouldn't be held hostage or harmed by congressional inaction. Let me be clear, government shutdowns are wrong, and we have to fix the structural flaws in the congressional budget process that makes that altogether too commonplace. But I also believe we have to have a safety net for our federal workers and their families to ensure that they're not held responsible, that they don't feel the pain if Congress fails to do its job. It's Congress's responsibility to consider a backup plan that would help families most affected should a shutdown occur, despite our best efforts to prevent it. This bill is that backup plan and would give federal workers insurance they deserve against financial hardship should Congress fail to do its job and fund the government. Chairman Cummings and Ranking Member Jordan, thank you for the opportunity to speak with you about this bill, and I urge you to consider taking up this legislation. I'd be happy to answer any questions that you have.
Any questions? Mr. Jordan? Any questions? Thank you very much.
Thank you.
Mr. Gallagher?
Thank you, Mr. Chairman. Ranking Member Jordan, it's an honor to be here. This is my first time testifying before the committee. It's
welcome.
Very nice room you have. I'm envious of it and look forward to working with you on many issues. I'd like to speak briefly on some of the bills I've introduced that I would appreciate being considered here on the Committee on Oversight and Government Reform. But this morning I want to focus on just one, H.R. 765, the Serve the People, Not the Swamp Act. The goal of this bill is to get Congress working again and to incentivize members to direct their efforts away from the swamp we call Washington, D.C. in a few simple steps. I think that most people, or rather in this body, we don't need a 700-page piece of legislation to make this place serve the American people better. I think we can do a few simple, easy-to-understand things to change the entire paradigm. To preface my discussion of the bill, let me say I understand that many other members of Congress may take issue with some of my bill's provisions. I understand I am only in my second term in Congress, but I think a lot of us come here with a sense that we need to sort of change the way business as usual is done in D.C., and then we never seem to get around to actually doing just that. We do things the same way and expect a different outcome, and that satisfies the literal definition of insanity. So to avoid that, I think the first thing we need to do, and this is the first section of the Serve the People, Not the Swamp Act, is to prohibit congressional recesses until Congress adopts a concurrent resolution on the budget that results in a balanced federal budget by the last fiscal year covered by the resolution. I think actually that would get at some of the issues my colleague Mr. Kilmer identified. And simply, this would keep us from kicking the budget can down the road each year and would be one way to stop Congress from governing by crisis or from crisis to crisis. And while you may think the particular approach contained in H.R. 765 is not the way to go, I'm sure we can all agree that our current budget process is broken. My Democratic colleague just spoke eloquently to that fact, and it makes no sense to the people who elected us that we should go on vacation when we have not resolved these budget issues. The second part of H.R. 765 would enact a 5-year ban on lobbying by high-ranking executive branch officials and members of Congress. Again, I'm still relatively new to Congress, but I've been here long enough to learn that basically every member is smart, hardworking, and most are here for good reasons. This is true of most senior-level executive branch appointees. Surely we're all capable, in light of that, of going home and embarking on another successful adventure after our time in office. We could start a business, we could become a professor, we could manage a charitable organization, or many other things. Why then do so many of our colleagues choose to lobby once they move on? And what kind of perverse incentives are imparted on us during our time in office by the prospect of cashing in for a lucrative lobbying job when we leave? While there is some opposition to this kind of revolving door ban on both sides of the aisle, taming the revolving door does enjoy bipartisan support. There's Democratic support in the House and the Senate, and I believe this is a common-sense target for reform for voters across the ideological spectrum. Finally, the third part of H.R. 765 would terminate further retirement coverage for members of Congress under the Federal Employee Retirement System. This is a reform in the vein of the previously mentioned lobbying ban. To get Congress working for Americans again, we must examine the incentives we give to members. In other words, there should be no incentive to stay here for as long as possible to collect a more generous pension, one that insulates us from life outside Washington, D.C. This should not be a job we aim to stay in forever, merely a season of service that we expend all of our energy on behalf of the people we represent, and then we go home and return to our previous life. And so these are 3 simple steps I believe we can take to change the incentive structure through which Congress operates. And ultimately, again, I just would say I respect everyone who disagrees with me and who certainly people have been here for longer than I, but until we change the way Congress operates, I suspect every 2 years we're going to have people on both sides making the exact same arguments about how we drain the swamp, how we change Congress, and then they come here with good intentions and then somehow nothing ever changes. And to expect different outcomes is patently absurd. Or, and this is even more destructive over the long term, we put all our hopes on the executive branch, presidential elections. We seem to surrender all of our authority to executive branch officials without jealously guarding our own and doing things the way we should be doing it here in the most powerful, what should be the most powerful branch of government, Article 1. And so I thank you for letting me go on. It's an honor to be here, and I hope you will consider H.R. 765, the Serve the People, Not the Swamp Act. Thank you, Mr. Chairman.
Thank you very much, Mr. Gallagher.
Thank you, Mr. Chairman. Mr. Gallagher, thank you for coming. So I just want to make sure I understand point 1 of your 3-point piece of legislation. You would say we get sworn in on January 3rd. We don't leave until there's a budget passed by both the House and the Senate, which actually shows a path to deal with this $22 trillion debt situation we have.
Essentially.
That's good. I mean, you look at the debt problem we have. You look at what it's now costing us to service that debt in interest payments a year, over $300 billion. Maybe that makes some sense. Now, obviously, Congress, I guess, could you could pass that law, but then they could change the law and say, well, we're gonna amend it, and we're gonna go home and not deal with it. But at least it puts some marker down that says we should take this seriously and stick around until we can agree, Republicans and Democrats, House and Senate, on getting a path to some kind of fiscal sanity. So I applaud the gentleman for his entire legislation, but certainly the first part, which is a big problem that we're going to have to address sooner or later. And like most problems in life, the sooner you get about fixing it, the easier it is to solve. So I thank the gentleman for coming today and presenting his legislation.
Thank you, sir. As my grandpa used to say, problems don't age well. That's as true in politics as it is in your personal life.
Thank you very much. We have a vote coming up. Ms. Plastic, we're going to hear you, and then I'm going to adjourn. You don't have anything? All right, fine. We will allow others to submit written testimony. Thank you very much. We're adjourned.
All right, thank you.
All right, now, thank you.
He was laying here. I didn't know if you dropped
Oh, thank you. Oh, yeah, I need every dime I can get.
Yeah, we all do.
Literally. Thank you.